Go. Okay, call this fire board appeals meeting with. Can I get a roll call? Yeah.
Verplank.
Here.
Beckman.
Here.
North. Here.
Okay, let's silence our phones away and I get a approval of the agenda.
Move to approve the agenda for January 6th, 2025. I'll second. Oh, not January 6th, January 27th. Let's go, holiday.
With some of the papers in this thing. Okay, motion and support, all in favor, say aye. Aye. Opposed? Okay. Can I get a approval of the minutes from January 6th?
I move to approve the minutes of January 6th.
We got a motion and a second to approve the minutes from January 6th. Favor say aye. Aye. Opposed? And now the approval of minutes from January 13th, site view for visit.
I move to approve the minutes of the January 16th. I'll second.
And we have a motion and approval to approve the minutes. All in favor say aye.
Aye.
Opposed? Okay. Moving on, unfinished business, we have none. Everybody new business, public hearing to consider appeals of 6545 Fairbrick Drive. Open the hearing. I'm not sure, am I allowed to say something here? Yes. Okay, I'm new to this. I guess I just want to point out, what the Board of Appeals is. You know, we make determinations on the code officials' applications, interpretation of this code, and we're nothing more than that. This board will have no authority to waive any requirements of this code or enforce any other codes. So I just kind of want to let people know what we are and what we're not. So that moving forward, we have a presentation by the applicant. 15 minutes.
I'm gonna give you a written, my presentation, because my voice is on you.
Uh-oh.
May or may not make the, phone. Yeah. Okay, just. Test. Okay. Right. I apologize that I spoke, I'm going to repeat it again. Been battling pneumonia for 6 months. I'm Randy Skipper. I'm here representing Culver and Karen Lamb through their LLC, Candy Ventures Limited. Having heard your comment, we're appealing the refusal of the Saugatuck Township Fire District to allow an existing access to the existing parcel to continue serving that parcel if the current fire trap house is replaced with a new safe house. The Lambs can continue legally occupying the existing residence with no further approval. But it is unsafe for handicapped persons and their family due to its cramped size, non-fire retardant materials, not being up to current code, and a lack of sprinkler. All the Lambs want to do is replace the old house with one that's handicap accessible, of fire retardant materials, with sprinkling up to current building codes. Yeah, you want them to upgrade their driveway to current codes if they do that. They cannot create the IFC required turnaround within their parcel. Architect has tried a number of different layouts and could not come up with one that meets the IFC and township requirements, while still leaving a feasible building footprint for a new ADA, Americans with Disabilities Act, compliant residence. They cannot achieve that, widening the driveway throughout the 750-foot easement, providing access, clearing overhead, and beefing up the weight capacity at 80,000 pounds would be wasted money. Fire trucks would still not be able to use the driveway, due to the lack of a turnaround. Standard sized passenger vehicles and comparable emergency vehicles can use the driveway. And the Lambs could make improvements to the driveway sufficient for ambulances to use it within the existing area that they have, including a turnaround sufficient for them. They cannot place a turnaround to IFC standards within their property. And the owners of the land over which the easement runs could threaten legal action against them if they remove any trees to widen the driveway. However, there are 2 fire hydrants less than 200 feet away from the proposed dwelling that we fully expect to be used in the event of an emergency. The owners whose property be crossed welcome that, put out the fire before their properties are damaged. What they would not do is give us express written easements, because easements are forever. They run the land forever, and they were nervous about that. We've seen in the record the concern that emergency personnel cannot cross the properties between Clearbrook and my client's property without an easement. Yet during our site visit, we all did that. It wasn't an emergency. We all crossed that property without an easement, without asking permission from the owner, and without a complaint from the neighbor. If you were willing to cross a non-emergency situation, it hardly seems likely your personnel would not do so in an emergency. In this situation, the local fire code must give way to the Federal Fair Housing Act as set out in our appeal of December 2, 2024. The township requires your approval of the driveway for new residents. We've acknowledged we cannot install a driveway that meets IFC requirements, particularly the turnaround. Yet replacing the old house with a new one is necessary for the handicapped members of their family to safely occupy their cottage. The Federal Fair Housing Act makes it unlawful to discriminate or otherwise make unavailable or deny a dwelling to a person residing in or intending to reside in that dwelling because of a handicap. Discrimination includes a refusal to make a reasonable accommodation for modifications in rules, policies, practices, and services when such accommodations may be necessary to afford the person the opportunity to use a dwelling. Our federal courts have held this applies to zoning and building ordinances, including our Sixth Circuit Court of Appeals that governs Michigan. Following the rationale of a Sixth Circuit ruling, an Ohio federal court ruled that local unit government had to allow a person to driveway off an alley behind their home instead of accessing the front because she was unable to climb the 18 steps to her house. So the local ordinance had to give way to the federal ordinance, the federal law. In that case, the court ruled that disabled person's request for accommodation must be granted if it's reasonable and necessary. And the municipality bears the burden of proving, of showing that a requested accommodation is unreasonable. The reasonableness is determined in a common sense approach that balances the needs of the parties involved. In general, the accommodation is reasonable, unless it requires a fundamental alteration in the nature of the program and imposes undue financial and administrative burdens on the municipality. The courts of honor said that necessity does not have its usual meaning in anti-discrimination laws. It requires a showing that the desired accommodation will affirmatively enhance the disabled person's quality of life by ameliorating the effects of the disability. A person's physical ability to do without an accommodation does not ipso facto invalidate the claim that an accommodation is necessary. In short, we don't have to prove that there's no other way they can access this property, use this property. It's sufficient to say that the existing house is a fire trap, not safe for them to use, and a new house would be. So the rule has to give way so we can have a new house instead of a fire trap. And refusing to violate a reasonable accommodation violates federal law. Now, I heard you say earlier that your job is just to interpret the code. Federal law trumps local law. Federal law requires that local unit government make a reasonable accommodation to allow those things and not let their code stand in the way. In the Vance case, there was a requirement that you have access by the front and not by the alleyway, where it said that had to give way so that the woman could access her house without having to climb 18 steps. A person is disabled if he or she has a physical impairment, such as a mobility impairment that substantially limits a major life activity such as walking. In this case, Karen Lamb and Culver and Karen's son-in-law have mobility impairments. As a result, they're unable to walk unassisted. In the current house, the rooms and passageways are too narrow to enable them to use a wheelchair or walker to be able to exit the house quickly. They desire to replace the current home with one that's handicap accessible, so they can use a wheelchair or walker to enhance their mobility and get out quickly in case of an emergency. The new home would also be fire retardant materials and sprinkled and up to current building codes, all giving them more time to exit in the event of an emergency. I know in your attorney's letter to you of January 24, 2025 says the township does not authorize you to waive the requirements of the IFC. Should be obvious, federal law supersedes a local ordinance. Under the Fair Housing Act, you must make a reasonable accommodation, if necessary, for a handicapped person to use his or her property. We all agree emergency access to this property is not up to current codes. There's no question about that. However, Lambs cannot make the fundamental changes you request for a fire truck turnaround at the end of the driveway in their property. There's just not room. They tried, their architect tried a number of different ways, could not come up with one. And the other requested changes would cost them likely over $40,000 in today's dollars. And those changes would still not enable fire trucks to use the driveway without a turnaround. And the Lambs can continue to occupy the existing house without making any changes. An exemption from compliance with the IFC code will enable them to replace a fire trap with a new, much safer dwelling. As I stated in our site visit earlier this month, our menu is limited. We have bad, the Lambs continue to use the unsafe fire trap currently on their property, or better. The Lambs replace the existing fire trap with ADA accessible home, fire retardant materials with sprinkling up to current codes. What we don't have on the menu is perfect. If they replace the fire trap with a new safer house and replace the existing access with access meeting IFC and township requirements, we simply can't do that. It's not available on our menu. Where perfect is not available, the Federal Fair Housing Act requires local units of government to accept better. A reasonable accommodation that allows the handicapped person to enjoy his or her property as others can enjoy theirs. That's all I'm asking. Thank you.
Presentation by the fire code official? Or do we have any questions for him?
Well, I'm here to do that.
Mr. Chair, Deputy Chief and I, with your permission, we will go up and we will present within the 15 minutes. Okay?
Yep.
And then after that, we would request that our attorney have an opportunity to comment. Hello, I'm Greg Janik, your fire chief. Welcome to the Fire Board of Appeals for the subject property 6545 Clearbrook Drive. The parcel which is up on the screen. I think board members, I encourage you, this is a PowerPoint presentation that there would be clarity if you were able to see the screen. I think it would help out. So you can see,
Great. Yeah, Wendy, can you just turn that? We'll turn it a little. Sure. Yeah, thank you.
good. So the subject parcel is circled in green, the green boundaries, the red line just shows when it originates from Clearbrook, it just shows driving up the Blue Star, going north and going south, the driveway, you can see parallels, almost parallels Blue Star Highway, so that's what that slide is about. So the initial application from the appellant was submitted. However, unfortunately, we weren't sure what codes were being appealed. So we asked for clarification on that. And in December of 2024, we received some clarification that all 6 codes were being appealed. What's interesting is there's appeal for the grade which could exceed 10%. If it does, there's things that triggers that kick in. This driveway is relatively flat, so we're not clear on why the grade is being challenged, because there is no issue with the grade. So applicant's appeal position is that poor access for large firefighting equipment is greatly alleviated by the 2 fire hydrants being less than 200 feet from the proposed dwelling. Mr. Shipper's appeal letter appears to be waiving access requirements due to the proximity of the fire hydrants. This is totally unrelated. This is not about fire hydrants. You will hear again and again, we do not require hydrant municipal water supply or any water supply for a single family dwelling. Again, we don't require it. Respectfully, we're just wondering what qualifications Mr. Shipper or other have to possess the weigh-in on a fire emergency response EMS operations. The International Fire Code goes on to confirm that IFC 1025 is applicable to anything built under the International Residential Code, known in Michigan as the Michigan Residential Code. And that code is applicable. What's applicable to single family dwellings is fire apparatus access. That's what we're talking about here. The code points out in 104 the responsibilities and general authority. The code official is the one authorized, not a builder, not a developer, not an attorney. There is clarity on this as far as who has the authority. On the screen, you will see it. I'm to clarify the application of its provisions. Purpose shall not have an effect of waiving requirements specifically provided for in this code. The fire code goes on to explain an approved route. This is important for the BOA to remember. You don't go by as the crow flies or line of sight on laying hose from a hydrant if we want to keep on capitalizing on the hydrants. Approved route is we can't drag 5-inch LDH across property. It's too difficult. You pull it off the truck by wrapping around the hydrant and drive on a drivable surface. You don't drive across grass, the truck sinks. So an approved route is very critical in fire operations. We don't drive across grass to lay hose. The fire code continues to say we acknowledge and recognize the value of the suppression system. In this case, a suppression system, a sprinkler system. It reduces the risk of fire. However, it does not negate the need for rapid access for EMS or other emergency situations. Carbon monoxide, natural gas leaks. In fact, a little over 3% of our calls are fire related, whereas 58% over that are medically related. So you've got about an 1,800% greater potential for fire engines, for EMS rather than fire engines. So I'll turn it to Chris.
All right, so I didn't realize it until putting the emails together that this has actually been going on since 2020, but for your packet. Anyway, as you can see on the screen, this was the initial submittal in January of 2022, showing how the compliant IFC turnaround would be challenging to fit. I would agree. Chuck from CKC Architects and myself discussed several options and solutions over the next few months. He then submitted this one in June of 2022 with a reduced 16-foot wide turnaround or a hammerhead. And in lieu of, and his offer was offering the 13D suppression system to reduce the turnaround width. We agreed. After discussing with the Department of Fire Prevention, we're like, this works. We'll make it work. Additionally, in the township ordinance, if you have a shared driveway, the whole driveway has to be 20 foot wide for the shared portion. So as you saw that path going out to the north on the first slide, the portion up to the neighbor's driveway would be 20 feet wide. So in this case, we agreed to reduce that as well to the 16-foot width. Mr. Shipper then got involved in his August of 22 email, essentially outlined that refusing to issue a permit would violate the Fair Housing Act. We work with, I'm not an expert on the Fair Housing Act, but these are the terms straight from their website. So a reasonable accommodation is essentially a necessary, or something we're gonna change to allow necessary for a person with a disability to have an equal opportunity to use and enjoy their dwelling. They have to show an identifiable relationship or a nexus between the requested accommodation and the individual's disability. So back in August of that year, we got our council involved as well, because we're not experts on the FHA, so we wanted to make sure we were going about it correctly. And this was as assisted by Bloom and Sluggett. There were no facts that indicated the disabled individual would be denied an equal opportunity. They simply alleged that it imposed a financial cost to the owner of the property. Further, there were no facts that would prevent the individual with the disability from receiving the same enjoyment of their property, and there was no relationship between the requested accommodation and the disability. And lastly, generally speaking, a modification of the safety requirement would be unreasonable and could potentially endanger the lives of the property and the homeowner, as it would, the accommodation would undermine the basic purpose of driveway access, namely the preservation of life and property in an emergency. So I would ask, were other codes followed or requested accommodations due to the FHA, GFI outlets, smoke alarms, railings, etc.? Are we only talking about ambulance access? The local building officials was unaware of any text in these regulations that would exempt these projects from safety standards that are otherwise imposed on the rest of the community. Mr. Shipper followed up with another email towards the end of August of the same year, asking us to instead use the access out to Clearbrook Drive as the apparatus access road, as it was only 275 feet. I followed up with an email to clarify, is there a legal easement? He responded that no, there is not. And we would presumably use the driveway from Blue Star. It's a little confusing as to what they were asking us to do, but nonetheless, we worked again with our attorney to respond to this in a formal letter. Being the busy summer season, it didn't get out until October, so my apologies for that, Mr. Shipper. However, this was our response where regarding the fire hydrant distances, they were irrelevant to the discussion regarding apparatus and ambulance access. We've never required a water supply for one single family dwelling, only for developments. And although we question whether the nexus criteria for reasonable accommodation was met, we've essentially offered it anyway, because we've agreed to the reduced non-compliant turnaround. We reduced the width of the shared drive from 20 feet to 16 feet, and both of the above were in exchange for the NFPA 13D suppression system being installed. Our goal has always been cooperation in a spirit of interest of moving the project forward for everyone. Reiterated that in our letter, 2022 letter to Mr. Shipper, that we would still accept this same offer, reducing the turnaround width in exchange for the system or suppressing system. Further, we outlined 3 potential solutions for him that even though a formal site plan had yet to be submitted, we suggested 3 options. 1, obtain a legal ingress egress easement to Clearbrook Drive to use that 275-foot route. Second was obtain a legal ingress egress easement to Blue Star Highway via the North Point Plaza. And lastly was improving the existing ingress egress easement that they already own to meet the minimum dimensions of the code, including that reduced turnaround width. We received a formal permit submittal in June of 2023 and omitted the previously agreed upon 16-foot wide turnaround with CKC. The formal plan review unfortunately did have to deny the approval of the project because there was no turnaround as required by IFC. And again, we outlined that we still would agree to that reduced turnaround width if they're willing to offer the suppression 13D suppression system. So continue to reiterate the same. Further, on the second page of that review, the water supply requirements were not applicable for the one single family dwelling. So putting the 2 together, the top of your screen is the formal permit submittal in June of 2023 that omitted the turnaround. I cropped and pasted in to scale the turnaround from the previous offering, and it sure looks like they still fit together. That the house still has room to build, they still show the required septic on the site, and we can have and maybe it's not a compliant turnaround, but we can turn around quickly with an ambulance as well as required. Not perfect, but best solution for everyone to move forward. So this is where they're requesting us access via the neighbor private property at 6549 Clearbrook Drive, also where the GPS currently takes you, which is why the plan review outlined the driveway needing to be changed, or the address being changed to Blue Star Highway, where we would actually legally access the property. This is a view of, you can actually see the cottage in yellow in the back of the neighbor's property, which is great until it happens to be sold and that neighbor builds a fence. How are we going to get 5-inch holes through that? Similarly, from Blue Star Highway, that we could have access via the North Point Plaza until there's a fence. Or what about a snow mound? How are you going to get that top over that snow mound? That's not going to be easy for anyone or quick. The logistics of moving a patient, on the light end, a patient being 205 pounds with a 125-pound stretcher equals 330 pounds. So I would ask, how are those two EMTs or two firefighters gonna lift that 330 pounds over that 20-foot long snow mound that is 5 feet high? It's not possible to do safely. So. Chief,
Thank you, Chris. So I can share with you in the 24 years that the fire code has been adopted, we have never accepted, approved access, primary access from somebody else's property. So we followed consistent patterns, consistent checklists. Neighbors change, fences, sheds, gardens, greenhouses are built without deeded access. As we suggested, neighboring property owners can revoke access at any time. Advanced life support, ALS. We asked for an opinion of site evaluation by AMR, one of your two ALS providers. The AMR supervisor went to the site, said the driveway does not appear to be a driveway, but a two-track. To carry someone out would take significant resources and be time consuming. Further, your second ALS provider, Supervisor Mike Spink, went to the site based on his evaluation of the residents in January. He has determined that in the current state, it's not safe to access via ambulance. Well, Chris.
So, as the applicant stated in their initial letter, the property is owned by K&E Ventures Limited, also DBA K&E Ventures LLC. Just for fun, I looked this up last week, and the property was, or the business was established for the purposes of real estate ownership and short-term leasing. So I do, although unrelated to this appeal, I question whether it's a home for family members for a short-term lease or rental. During 2024, we conducted 77 reviews of single-family dwellings alone, not including commercial projects, and all of them had the exact same 16-foot wide driveway and a 20-foot wide IFC compliant turnaround when the length called for and was applicable. Another CKC project from September of 2024, they were looking to tear down an existing dwelling and build a new one on an expanded footprint. They put in an expanded, they put in the IFC compliant 20-foot wide turnaround as well as a new driveway, and the project is under construction today. So just a reminder to the BOA, respectfully, what the limits on the authority are, is your role is to determine if we have incorrectly interpreted the code. Provisions of the code do not fully apply, or an equivalent method of protection is proposed. Respectfully, you do not have the right to waive the requirement of the code as requested by Mr. Shipper. And lastly, we will still agree. So we believe we did not misinterpret it. 503 does fully apply, and there has not been sufficient method of alternative provided. And we stand behind our 2022 offer that although we still are unsure if they meet the reasonable accommodation, we'll agree to reduce non-compliant turnaround, reducing the shared driveway width to 16 feet in exchange for that 13 feet suppression system. So thank you very much for your time, and we'll be happy to answer any questions you might have.
Thank you.
That alarm went off at 14 minutes. Also. Presentation by other parties, limited to 3 minutes.
I'll keep my remarks short because I think everybody's made a lot of the points I was going to speak to. I did, Chairman Beckman submit a letter. This was, I guess you could take as a supplemental staff position statement on behalf of the Saugatuck Township Fire District in this matter. And part of my letter, I guess the point was, is to address the reasonable accommodation request issue. And Chairman Beckman, I would agree with your point from before. I don't believe that this board has the authority to waive the requirements of the IFC. The authority of this board is delegated specifically by the Saugatuck Township ordinance. So the limitations and provisions of what this board can and cannot do are established by that. And one of those provisions in section 16-27 of the Township's Code of Ordinances adopts the language from the IFC, which says the board may not waive the requirements of the IFC. As far as the reasonable accommodation request itself, well, let me back up 1 second. One of the things that was pointed out in the application form was that an argument that the provisions of the code do not fully apply. I don't think that that's actually been addressed in anything that I've seen. I think that we're all on the same page that the IFC applies to this property. So I don't think that there's any merit to that argument. To the extent that reasonable accommodation can be considered by this body, it would probably fall into that last category that an equivalent method of protection or safety is proposed. And that's addressed in section 3 of the submittal that I sent in. And just to break it down, a reasonable accommodation request under the Fair Housing Act effectively has 3 elements to it. Whether it would provide equal opportunity, it is necessary, and third, that it is reasonable. So the first 2 of those 3 elements address the impact that the request has upon the party who is requesting the accommodation. How is it going to benefit them? The third one, the reasonableness argument, element, really addresses what effect does this have upon the governmental agency? What effect does it have upon the fire district in this case? And that's addressed on, beginning on the 4th page of our letter, and we believe that this would have significant impacts. Because effectively what this request would do would be to require, because the driveway itself cannot safely accommodate a fire apparatus or an ambulance, according to the STFD and light BMS, that it would have to be accessed, required to be accessed through a different property. And because we do not have an express easement that clarifies that these neighbors have allowed the STFD or light BMS or whomever to trespass onto their, to go onto their property with an easement, then they would effectively have to trespass. Now, when you look at Michigan law, it does allow fire personnel to trespass across property to address an emergency that's happening on another piece of property. But this would be effectively mandating that they would have to do that to respond to a problem or emergency at this particular location. That's a little unusual. Moreover, I was not able to find in all of my research any case law at the federal level addressing the Fair Housing Act where it was used to allow an accommodation from a fire code regulation. Usually these codes are specifically designed in order to protect life and protect property by making and facilitating the job of fire service personnel easier. And therefore, I could not find a case to that effect. I think there are issues with snowbanks, there are issues with fences, those are all considerations. If the department's going to have to trespass over one of the neighboring properties to reach this one. And these are all things that you need to consider. Obviously, the reasonableness of an accommodation request is a highly fact-intensive question. And it's up to this body to determine whether or not you believe that that reasonableness element has been met in this situation.
Thank you. Any other comments or anything?
Anybody on Zoom wants to come in either, so far nobody has a hand up. But I guess if anybody does, they could respond, maybe. Applicant is, other than a couple fire personnel going on there.
I can make one more quick point. If I could.
Go ahead.
Obviously, the decision is up to this board. What I would say is if you do want to, if the decision of the board today is that you want to deny the request, I would recommend that you decide to tentatively deny that request and subject that to your later approval for a written decision document on this appeal. And that we be, the fire chief in our office be permitted to provide a proposal for this board subsequent.
Appreciate that, thank you. Discussion. Yes, moving on, public hearing. Do we need a motion to close it?
I move we close the hearing.
Second.
Got a motion and a second to close the hearing. All in favor, say aye. Any opposed? Close the hearing. Action by the board.
I would table the action by the board. Or some written statements from the board. I don't feel I can decide right now. I want to mull this over and decide. or actually write up my thoughts on the decision. And I guess that we told you after that.
If you want to table it, you can. That would mean that we would have to take this up at a later date.
Right.
And then, I would recommend if you want to do that, then perhaps what you do is you just write up your own notes and that those could be shared at a later date. If that's what.
I thought we had 7 days to respond.
I think our response has to be in writing. I think we can vote or. I'm not quite sure. I know it has to be in writing.
Well, whatever you want.
Well, I know the way, after reading everything and hearing everything, I know the way I feel. But that's one personal trait. So,
I may be misunderstanding, but it seems like we could make a decision today and then follow it up with a written rationale.
Well, what we would propose to do would be to have staff prepare a drafted decision document that would be approved. Provided that you tentatively want to make a decision today based upon that condition. But that's up to you, whatever the board members would like to do.
So I guess I'm not understanding. So we make a decision, then we give our reasons for that decision to you and you write up a document. Is that what you're saying?
Basically, yes. What we would do would be to prepare an actual formal resolution for the board. That would be the actual decision.
And then do we have to approve that or?
Yes.
but
So
you
we
would
do have to
be, you would be representing the Board of Appeals.
I will be representing you, preparing a written copy of what you decide.
So, trying to figure this out, do we have to make a decision right now, or do we wait and submit a written decision within 7 days?
You can table the action. You can either table that without making a decision, in which case then we will have to reconvene, where you will then have to make a decision, which could then, again, still our recommendation would be that the decision be subject to our, preparing a final decision document that aligns with what you decide to do, which would then have to be approved at yet another meeting. So, and if that's what the board wants to do, we can do that.
What would be the alternative?
You can make a tentative decision now, and then we can come back, prepare that decision document, and then you can reconvene to approve it. I guess you let me know how you want to do it. We can make that happen.
I don't care either way.
Well, there's multiple. There's some things in here I agree with, and there's some things in here I don't, and I don't think I feel comfortable just spewing off. Voting for, yes, I agree with this, no, I don't agree with this. So I think we ought to step back and reconvene.
I don't. Think that.
I will second your motion to table.
Okay, we got a motion. Did I make a motion to table?
No, I didn't.
Okay. Being, motion to table and second by North, all in favor, say aye. Aye. Opposed? There we go.
Do we need to set a date to remove it from the table?
That would probably be best if we do that. So whenever you're available to do so.
Yeah.
We have a workshop at 4 also, I can.
Well, we could convene before the workshop,
I can do that.
maybe at 3:30.
Yeah, I should be able to.
That's on the 3rd.
The 3rd. Correct. Let's set up a meeting for February 3 at 3:30. We want to meet here or at the fire station? I guess we can announce that.
If I may, I would prefer you do it at the station because we've got the workshop right after that.
Right.
And this is probably a 45-minute setup for 3 people.
So I'll just plan on that.
Right, so you've got that fire station down the road.
Yeah,
Mhm.
okay, any members comment or public comments? Getting on Zoom,
Nobody's raising their hand, though.
okay, one of you, number comment?
I just have a few things I want to check out with the township.
Fair enough. My only feeling, I will say this right up front, that I think there's a lot of other things going on here beyond the scope of this board review. And that's why I spoke to that before we started. The fair housing, you're talking judges and Supreme Court and everything else, not an innkeeper, a salesman, and a retired educator. I just want, I need to be upfront, I'm very sympathetic to the Lambs. I'll give you my opinion about the driveway. I've lived on this road for 27 years, never knew that was there. And if I haven't noticed it, then how are these guys or someone coming from Grand Rapids to save a life? So I think,
In the dark, in the snow.
yeah, so I think that was significant. That's just my opinion, and I'll leave it at that. So I'm think of movement.
I'll make a motion to adjourn.
Second.
We are adjourned.
Thank you, board.
And I'll be honest, I don't disagree.